Good evening, everybody, and welcome to our regular Wednesday stream. I guess it's not our regular Wednesday stream because there's no Evelyn here. Evelyn has abandoned us. But in Evelyn's place, I have once again. You may remember him from the Hope Not Hate analysis we did. But I'm joined by Reactionary Reading Law. Good to have you.
Hello, thank you for having me.
For those who don't know who you are, because I do have some stuff up to shill for you here. Do you want to let people know kind of who you are and
Hello.
what you do? Yes.
I've often been called by friends the Sensible Centre's favourite legal strategist. I do articles on legal and political strategy. I'm also a public speaking tutor and a law student.
If you guys want to check your stuff out, I'll probably shill you towards the end as well. But your stuff is in the description if people want to find you. So we have Reactionary Reading Law. You're on Twitter, and you also have a Substack, which I am subscribed to because I wasn't. I thought I was, but I wasn't. So I am actually subscribed to that now because the thing is, the people I like, I actually just go and manually check their Substacks because my email's a mess. So.
Yes.
As
did you enjoy that article, by the way, Mum's on the Run?
I did, yes. I did enjoy that one. But if you guys want kind of analysis from a legal perspective, Reactionary Reading Law is the place to go. Because I know you guys are keen on the slightly more boring aspects, let's say, of this. Because the boring stuff really is how you win and lose.
Yes, very much so.
I did enjoy that one, yes. It was a good article. I did forget to say also that we are back. So, hello, folks. Hello, John Morton and Anthony Key in the chat. I do see our members there. To do my own shilling, if you guys want to support the channel, the best way to do that is via the Ko-Fi link. Although I will probably shill the other stuff that we have later, so I'm not just front-loading with too much shilling. Although, I will... How's the weather where you are? People seem to like a slight weather report, but it's just been horribly muggy and cloudy here.
Yeah, it's been muggy and warm today, and now it's starting to rain.
Oh, dear.
I'm in Scotland.
Condolences.
Although it's much better than the weather was over my summer holidays when I was staying in and around London. It was an absolute nightmare. It was boiling hot. I had to go on holiday to escape it. Got lots of climbing done, though.
Oh, that's good. You mentioned Scotland, so I will just mention that we do have the No More Scotland thing going on at the end of October. Links in the description, and there'll be a bit more detail on that a little bit later.
I will be coming to that.
Oh, good. It'll be good to see you again. But yes. Today's topic is something we've been teasing for quite a while, actually. One of the most, I think, oppressive and far-reaching pieces of legislation in recent UK history, which is the Equality Act. It's been a feature of quite a few of our streams. The Conservative government keeps trying to appeal to the Equality Act. It seems the Equality Act is so powerful that haggling over what the Equality Act really means is a large part of politics now. But I brought Reactionary Reading Law on because you have a legal background to go over some of the particulars of the Equality Act and how it functions. There's a little bit of case law here, but not too much. We're not making this too dense. But really the key aspects of what makes the Equality Act so egregious for Britain, and especially for people like us who say things and do things that run counter to the grain. So, I lost the window here. There it is. No, I have not. But I actually have the entire Equality Act here to browse. It's the government's legislation website has been really acting up today. It's been failing to load a whole bunch of stuff. I was a little bit worried I wouldn't be able to get this all up. But you also did prepare a quick slideshow about the worst bits of the Equality Act. So what, in your opinion, are the worst bits of the Equality Act?
The worst bits, in my opinion, is the public sector equality duty. So that's section 149 of the Equalities Act, but also section 1.1, because what that does is it references and is meant to apply to the public sector equality duty, but it points out that instead of having a duty for public authorities to promote and ensure there is equality of opportunity, it suggests that these public authorities have a duty to ensure equality of outcome in certain instances with certain groups, and those groups aren't us.
No, those groups are most definitely not us. I have some guidance here from the Crown Commercial Service I inserted, actually, which talks about the equality objectives. They say that the Crown Commercial Service commits to the civil service ambition to become the UK's most inclusive employer and will continue to increase the representation of currently underrepresented groups to make Crown Commercial Service more diverse. They're quoting really from their public sector equality duty here when they say this, though. The aims are reinforced by our Inclusion Diversity Strategy 2020 to 2025, which has the following key elements. Again, representation, ensuring that CCS workforce is representative of the diversity of modern British society. The outgrowth of this really is that if you are a public sector body, you have to have an inclusion and diversity strategy. It is part of these provisions.
Yes, certainly. And what's quite interesting about this legislation is it applies in a similar way to affirmative action legislation in the US. So if you are a large company that requires or gets government contracts, you're going to have your own diversity and inclusion strategy that is on par with that of public bodies.
Yes, that is the big one as well. You'll see here that, having due regard to the need to advance equality of opportunity between persons who share the relevant protected characteristics. That is not just race, and we'll see these coming up time and time again. It is age, disability, gender reassignment, pregnancy and maternity, race, religion or belief, sex, and sexual orientation, which would seem to cover everybody, but it really doesn't.
No.
It's quite particular, as we'll get to when we talk about case law, who the Equality Act covers and who it doesn't cover. But I would agree that the public sector equality duty is the biggest stick, I'd say, that people would find on a day-to-day basis if they run a business, and especially, like you said, that business interacts with the public sector. Because as you said, it's not just people in the public sector, it's everyone who contracts with them, which are most businesses. Most large businesses will at some point deal with the public sector. I know I've had to in my line of work. A lot of people who do kind of construction and engineering have to deal with a lot of this stuff. Luckily it's a lot less pervasive in our industry itself, but there's a lot of paperwork that needs to be done in regards to the Equality Act, even when you're doing something as simple as like building a wall in a school, let's say, or refitting a air conditioning system in a classroom. There's all kinds of pitfalls you get into every time you interact with the UK government, and the Equality Act is a large part of that.
Yes, well, on the topic of the public sector equality duty, what it means in practice can be extremely broad, because I know in the legal spheres and similar spheres such as management consultancy, accounting, and anything else you care to name, large companies of accountants, lawyers, and what have you end up being paid and getting subsidies to hire minorities and women.
Yes.
So it's at the point now where if you go into a given legal department, especially a large one, a significant number of the people within that team will be diversity hires.
Well, they have to, because as the organisation, as the face of Britain changes with the mass immigration, that's the whole trick here. As the ethnic makeup of Britain changes, the ethnic makeup of all councils and all public bodies must also change at the same rate. So if you have a static amount of staff, if you have legacy staff who are hired in, say, the 80s, which is not inconceivable for people who are in their in their 70s. If you've got an organisation that has people staying on kind of beyond retirement into their mid-60s, right into their 70s, it's very likely that they were hired on, because of the way the public sector works, in the 1980s or the early 1990s, which means that they come from a Britain that had a much different ethnic makeup than the one now. So naturally, even if they were applying these standards back then, this is an ever-moving target because of the other interlocking parts of it. And it seems reasonable for a static democratic makeup of Britain, but for a wildly fluctuating one, it makes hiring very difficult, because it does mean that, yes, basically all of your hires in a certain organisation will need to be diversity hires. They'll need to be hires from groups that are quote unquote underrepresented in your company, and you have to justify, if you're not hiring these people, why, and it's very difficult to do so.
Well, even if you had a static population, this stuff is normally a nightmare, because I've seen how it works in other countries, especially in places like the Caribbean, South Africa. You end up getting a significant amount of useless diversity hires who are a danger to themselves and other people.
There's a lot of, I've witnessed it too, when I've dealt with kind of larger organizations when they've been onboarding people. There is this real desperation that they need to find somebody with certain characteristics. And a
Yes.
lot of the time they will double or triple up on jobs. There's certain sectors, it's become a joke that the HR department of any company is where they stick all the diversity hires, because it's where they think they can do least damage.
Yes.
But that leads to kind of dispute resolution being very much tied up with these people and tied up with specific groups. It usually tends to be specifically in the past women who were put in those departments to try and bolster
Yes.
that up on companies that have, say, all male boards, which has been frowned upon. But it's just everything. And at any moment, somebody can come to you and go, justify why your company's makeup is not completely one-to-one reflective of the makeup of Britain. And you have to stand there and go, and it is a real bum clencher for people. Because I've been on good terms with people who've been higher up in some of the companies I worked for before, and they've basically had people come round when they've been dealing with like UK government contracts and be like, right, I want to see like all your workforce, I want to see all your diversity initiatives. We want to know how you're meeting this target, that target. How do you do this? How do you do that? And it's part of the bidding process for certain things.
Yes. Well, I've spent lots of time on construction sites, especially this summer, because I've been working for a company that basically fixes and does things for companies when they've got problems with the diversity hires messing stuff up. And if you're in the construction industry or an industry that is somewhat dangerous, these diversity hires are really scary, because the amount of people I've seen in construction sites who don't speak English and just go wandering somewhere.
Yes. I believe in certain places they have specific helmet colors, because this has come up on stream before, actually. The fact that on certain sites, it's supposed to be for managers, but certain sites will have an unofficial designator that people say wearing blue hard hats or hard hats of a certain color do not speak English. And that's relatively common. I found it's mostly in, let's say, more manual trades. There's very few of them in what I would consider skilled fitting. All your gas guys, all your fire guys. That none of them really are these non-English speakers. A lot of it is fetch and carry work. But if you end up with somebody trying to tackle a task they're not qualified to do and they don't speak English, that is a much bigger problem. And a lot of these organizations are hiring these people directly, you are right, to make up their numbers. And sometimes they're not quite monitoring what they're doing. Not monitoring what they're doing. So I'm not surprised you've been brought in that capacity. That's quite amazing to hear that, actually. Because we both dealt with kind of the other, so you've dealt with the legal side of it, I've dealt with the practical side of it, doing project management based stuff before. But this is the real world outgrowth of the public sector equality duty. It's not something that is just imposed on the public sector. I will stress that again. It is something that everybody who interacts with the UK government has to worry about, and that is basically every business in Britain.
Yes. If I may make a point, I'm doing a piece at the moment on rape culture and the rape culture we've imported. And what I've come across is some guidance that is in practice for the police that is part of the police's public sector equality duty report 2022 College of Policing.
Okay.
And page 26 of that lays out that they are wanting to make disciplinary tribunals more inclusive for Black and ethnic minority people, BAME. But when you read this, it's essentially saying that they're going to have lower standards of behavior for Black and ethnic minority police officers.
I've seen bits and pieces like that before contained in reports, but I didn't realize they'd laid it out so explicitly. Do you have a quick link to that so I can get that up on screen?
I do. I'll put it in the show notes.
Do shove it in the show notes here, but I'll get that up in a sec. But to keep stuff moving, that neatly brings us on to where a lot of this comes from, which is the Race Relations Act, which is one of the origins of the Equality Act. And also the Equal Pay Act was folded into the Equality Act. I also believe that the Sex Discrimination Act and the Disability Discrimination Act were also folded into the Equality Act, which makes it a monstrously big and all-encompassing piece of legislation.
Yes. So Section 71 of the Race Relations Act gave local authorities the responsibility of ensuring that there is equality of opportunity for those with different races. And this may sound unobjectionable to the few liberals we have in the audience. However, I'm going to draw on a point that Alex Kashuda made in her speech at NatCon. She pointed out that there's no such, you can't measure equality of opportunity, so you only have equality of outcome to measure by. And part of the reasoning that people who write this legislation adopt is all people are equal. So when you have a disproportionate outcome or representation in a given industry, the logical conclusion there that policymakers will come to is that there is unequal opportunity. So what this means in practice, more opportunities are given to ethnic minorities than would be given to the general population.
Yes. It's a natural kind of outgrowth of them playing catch up as well. But it is also very explicit. There's a lot of systematic issues. There's also a lot of very explicit issues. Apparently that webpage isn't working.
Okay, right. I'll put it on my Twitter when we're done.
Oh no, that's not your fault. That's them.
Yes. Okay.
Lovely. I was trying to get them to give me a PDF of it. No, that's fine. It's refreshed now. Wow, how terrible. Which section was this, by the way? Sorry.
It was page 26.
I've got the HTML version here, I'm afraid. So
okay.
There's very, very fractured bits here. Workforce, sexual orientation, blah blah blah. Observations. Yeah, I've been trying to find that. Anyway, I will make sure it's in the show notes. But I do believe you that they have put the provision in there. I have had tremendous trouble trying to get stuff to load today that was loading just the other day. Yeah, it is very oy-vey down, but it's very difficult to get hold of some of this stuff because it seems that the government's own infrastructure for displaying these things is just crumbling before our very eyes.
Diversity highs.
Yes, we are very much on a collapse watch here. I'm declaring a collapse watch because even the stuff to highlight the collapse is collapsing.
Yeah.
But it does follow on though from the provisions of the Race Relations Act, because that's, as you said, this really is where the positive discrimination stuff comes from. And the end point of positive discrimination is you have employees who shouldn't be in the organization. And the ultimate end point, which is in the policing report, which has been very obvious for a long time, is that you will have to treat the people who shouldn't be there differently so they can stay there. Otherwise, with equal opportunity, equal application of the rules, they wouldn't be there. It's really it's almost like childish logic, but it's something that this falls foul of.
And something else that does form part of the public sector equality duty is equity-based policing. So equity-based policing is policing that is done in a way that is meant to restore opportunities to certain groups. And what this means in practice is certain communities are policed less regardless of how much crime they commit.
It's been a very common theme really since the 60s.
The McPherson report.
Yeah, it was codified in the 1970s, but it's happened a long time before then. It's been an unspoken thing since the Race
Yes.
Relations Act, because a lot of people are very afraid of the Race Relations Act. But it really was codified by the Stephen Lawrence report, and then was it the Shawcross report, or is that a different one? That's a different one. But
No, the Shawcross report is a different one. That's the one into how Prevent works.
oh, that's Prevent one. There was the second. There was basically Stephen Lawrence report to Racism Boogaloo. It was called the Grey. It was about Baroness something or other.
Yeah.
We've
I
talked
haven't
about
heard
it
of that one in particular.
We've talked about it on stream before, I believe, but it is basically just the Stephen Lawrence report 2.0.
Yeah.
Because they did the whole thing of they declared the police institutionally racist again.
Yes. Well, the interesting thing about that is they may have done it in the 60s and the 70s, but what's interesting for me is the fact that it's codified into law.
Yes.
So when you have the police refusing to go to burglaries or letting off sex offenders without charging them, as happened a couple of months ago, it becomes quite concerning and quite obvious to the layperson that actually maybe the reason why Britain's turning into such of a shithole is because the policing is favouring certain groups, or not even favouring them, because I'm not really sure it's very good for someone's soul being allowed to rape children or stab people unpunished.
But it's more that it is treating different groups differently, and very much it is facilitating crime for certain groups, really. But it was the Casey report. Sorry, it's a very generic name. No wonder I forgot it. But it was Louise Casey, probably soon to be Baroness Casey. Met Police found to be institutionally racist, misogynistic, and homophobic, which very much tries to appeal. This report interlocks with the Equality Act perfectly, because what she's saying is that they are not meeting their statutory public service equality duty. They are not meeting what is expected of them in law, which is really something they can never meet. They can never physically meet it. They will always be chasing it because it is an impossible target to meet. And that's really how all of this works. It's endless in its scope.
Certainly.
What I was going to ask you quickly was about a little bit of the. I'm going to put the images back up here. Sorry. A little bit of the. We've gone through the public sector duty. We've talked a little bit about the Race Relations Act, although we should probably go to Section 71 before I move on, and that is to do.
We already touched on that.
Yeah. Sorry, is it Section 2, which is the police?
No, that's a note to myself. Sorry.
Oh, okay.
In 2000, after the McPherson report, the Race Relations Act was updated. So included within Section 71 of the Race Relations Act up until the Equality Act was the general duty of local councils to ensure equality of opportunity, but that was expanded to the police.
Oh, okay, yes. That makes sense then. And we talked about the public sector duties here. And the outgrowth of that is, it's the non-crime hate incidents. It's the lowering of standards in the public sector, which we have just talked about briefly, but it's also equality-based policing. But the non-crime hate incidents are something that I found interesting because it's they have a very dubious standing in law, and there was a guidance put out recently for it, the government trying to row it back. But really, they are still allowing these non-crime hate incidents to take place. What do you think in the Equality Act has led to that? Or do you think this is them really just taking it on themselves and interpreting it as harshly as possible to record these things?
Right. So I did a case note about a year ago on Harry Miller's Supreme Court case. It's on my Substack. Go and find it.
Okay.
But in that case, the judge makes clear that non-crime hate incidents are required by law as the police doing or complying with the public sector equality duty.
So I know there was a decision that said that they did not go above and beyond because the consequences weren't particularly harsh for having this declared, even though that's not true. If the police, if your employer does a background check on you and there's non-crime hate incidents on file, then that's going to rule against you. But I didn't realize they'd said that it was part of the equality duty. I'll go and get that back up. But
So in that case, what happened was Harry Miller won on a proportionality basis, and the court found that the way that the guidance was worded didn't give adequate protection to freedom of speech.
Yes.
So that was all they won.
So that's where this statutory guidance came from. Really, it's a very weak code of practice because it doesn't really lay out. It just says, oh well, you have to weigh the positives and negatives against freedom of expression. But it's more of a finger wag than it is a decision. It actually changes nothing. But thank you for the clarity on that. I had seen the bit of the decision where they said it wasn't disproportionate, but I didn't realize they had actually fully linked that to the Equality Act. So that's the last piece of the puzzle. So really the police can argue that their hands are tied, that they have to record these non-crime hate incidents if they would violate the Equality Act, because that is part of their public sector equality duty, which is a very sly way of doing it.
Because what I've noticed in recent years is what I'll broadly term the right, or the sensible centre, or sensible people in general, have been winning a lot of proportionality-based victories.
Yes, they have.
What I mean by that is the policy itself isn't wrong, in the legal sense anyway, but the way the policy is applied in certain instances might be unlawful. So I don't particularly want to talk about the trans nonsense, but I'm going to have to. There was a case recently that Christian Concern jumped on that made its way to judicial review. And the court found that it was unlawful to discipline children of primary school age, and I think in this case the child was about 4, for questioning a child who displayed as the other gender than they were, but it was only found disproportionate because the school was labeling them as transphobic in their education reports. It's still perfectly lawful for children to come in dressed as the opposite sex, and in fact, from my own experience from some of my little cousins, it's completely normal now to have children come into school dressed as animals and pretend to be animals.
Yes, it's very much the Tumblification of education. It's the sharp end that people witness. But you are right in that I saw some of the same stuff, which is that the proportionality stuff seems to be about recording of the instances rather than the instances themselves, which is curious.
Yes.
The very fact that it seems to be it seems to be a case that you are allowed to apply to children is especially egregious, but it seems to be something that they do very often. Well, they do like going after children. We know that much.
Yes.
But it's horrible that this happens in schools, and I'd forgotten about that whole person identifies as a cat in classroom and all that. A lot of that is deliberately silly.
Yes.
And it is deliberately like ritual humiliation stuff.
Yes.
But it is interesting you said that there have been these proportionality victories, that a lot of the victory come from the fact that it's very, very clearly disproportionate what's being done, because there are these little caveats on even things like the Equality Act. But even when they take what is the maximalist view of the Equality Act, even then people are kind of going, well, the maximalist view doesn't cover all the stuff you're doing, but we're going to do it anyway, but we're going to maybe say you can't record it in certain ways. That seems to be the extent of the victories. Because really, I know you said there's been a lot of proportionality-related victories, but if you read a lot of the decisions, they haven't really been victories.
No, they haven't. And that's what I mean by proportionality-based victory.
Yes.
You win in a very specific sense that doesn't apply.
No, and that's been... me and Evelyn have actually been pointing this stuff out. We're not legal minds, so we don't have the exacting legal language sometimes. But the Free Speech Union and the Democracy 3.0 people who seem to be linked up with them are pushing a lot of these cases that end in proportionality victories. and mostly seem to be there, to get them paid, to get lawyers paid, and to get activism done. It doesn't actually create any legal precedent. It is effectively, it's not quite pissing in the wind, but it is kind of just pissing on the wall. It doesn't really do anything. And a lot of people don't understand why. They see legal victory and they think, "Hey, we've won, we're winning." But then they don't understand the fact that really, in actuality, what's happened is that the practice has in some ways been further codified as within the law.
Yes. Well, this is something I find very interesting. Am I interrupting you, by the way?
Oh, no. I was taking a sip of my drink there. Go ahead.
I've been looking into this in quite a lot of detail on both sides of the pond for a project that I'm doing that I'm not allowed to talk about. Subscribe to Empyrean Press. But the how judgments are applied and how they're written is quite interesting, because in the UK side, the judiciary isn't that powerful. The judiciary is basically an administrative body.
Yeah.
Whereas in the US, the opposite is true. The Supreme Court can make decisions that effectively change law nationally. So the Federalist Society across in the US, do you know what the Federalist Society is?
I'm aware of the Federalist Society, yes. I'm sure quite a lot of audiences as well.
The Federalist Society is basically a society that does academic debates and represents conservative lawyers and recommends them for being appointed to the judiciary. But unlike their left-wing equivalents, the Federalist Society doesn't have a ideological commitment, and they don't, because they're conservative justices, they don't actually believe that it's the Supreme Court's job to legislate from the bench, which is an idea I find completely ridiculous, because for about most of America's history, the law nationally has only been changed by the Supreme Court.
Yes.
So in the US, we've seen lots of Supreme Court decisions that should have put to bed certain policies, such as affirmative action. But what the affirmative action one, all that did was, I forget the name of the case, was make it unlawful for Harvard to discriminate against Asians in that particular way.
Yes, there wasn't, a lot of the headlines were affirmative action struck down, when really it was a legal particular. They were settling a particular case, and they weren't legislating from the bench is supposedly it's a dirty phrase in America. It's something the judges are accused of. It's not something judges try and do. Here in the UK, if you read our quote-unquote unwritten constitution, our unwritten constitution is supposed to be made of legal decisions. We're supposed to be the opposite. The UK is supposed to be the place where judges make laws, and the US is supposed to be the place where judges simply compare laws to the constitution. But actually, the way that the power of the judiciary works on paper is backwards than it is in reality, because we don't have a constitution. Case law can technically affect the law, but it very, very rarely does.
I really disagree with that.
All right. Well, I mean, in theory, it could.
Yeah, I'm not even sure that's true in theory, because the British Constitution, or the uncodified Constitution, is essentially made up of Acts of Parliament. So on paper, and I would say in theory, we have parliamentary sovereignty in the UK, and it's been that way since the end of the Civil War. The issue with judge decisions and judicial decisions is it comes on the idea of common law. But the problem with common law is common law means case law, and case law in the sense that we know it today has only existed from the mid-19th century onwards, because in England and Scotland and Wales, there wasn't necessarily a strict legal system up until the 19th century. There had been attempts to make an English legal system from the 15th century onwards, but it didn't necessarily work because the monarchy was always being overthrown or whatever was happening. So prior to the 15th century, and you would have local courts, you would have merchants' courts, you would have religious courts.
And you'd, of course, have magistrates. There'd be a whole series of magistrates that would administer a lot of local justice as well, yes.
Yes. The person you need to see on this is Radlib, because Radlib goes into a lot more detail than I am about to. But in England, you would have local decisions that were made by your liege lord or his appointed magistrates, depending on what time period. So once you move on to the modern era, it is true that we do look at cases from the medieval period, especially in contract law, but those are cases made by the Merchants' Court in London at that time. So what I'm trying to say is common law doesn't really have a very significant impact on the Constitution itself. The job of common law and case law is to help the judiciary interpret legislation.
Of course, in practice, it does not. But if you were to be given a fag packet version of how the English system is supposed to work, a lot more weight is put on the judiciary than they actually have. I'm talking about kind of de facto versus de jure a lot of the time.
Okay, yes.
Yeah.
But I think the problem with that is, and the reason for that is, that way of explaining the Constitution is coming from a liberal point of view, and people
That's what I mean by on paper. It's as it would be explained to somebody, the judiciary in the UK would look very powerful, when really you're right, they are conduits, they are paper shufflers, they are mere interpreters, and they do not have really any standing to legislate from the bench.
Unless New Britain happens.
Unless New Britain happens, in which case they will still not have power to legislate from the bench, because all their decisions will be paralysed by 15 layers of council reviewing it.
Yes.
It's apparently me and Evelyn were the only two people in the country who read that entire document in full.
So I have as well.
Okay, we're the three people in the country then.
The three people.
Fair enough. I would like to move on, because we're not too short on time, but one of the big aspects you highlighted, and I wasn't quite as aware as this as a standing out point. I was aware that the harassment provisions exist, but looking at them in the Act and some of your commentary here, it's very clear that one of the other big kind of teeth, if you will, of the Equality Act is its incredibly broad definitions of harassment.
Yes.
To the point that anything can be harassment. I would just point out as well that I got up the sorry kids, it'll be an imaginary victory this year, because that's perfect. I'm shifting the Overton window. I'm red pilling the north. I'll send you that one after, but that's one Evelyn made.
Please do.
The imaginary victory one is just it does.
Yeah.
I post that every time there's one of these kind of Supreme Court decisions or anything like that. But yes, I will quickly.
I'm going to spam fair cop with that.
This is also in the Race Relations Act as well. But yes, engagement in unwanted conduct that relates to a relevant protected characteristic, which is insanely broad. If you want to go into this from a legal perspective, because it's unusual things to be this broad in British law.
Yes. So normal harassment is defined in law in most places and contexts as the unwanted contact to another by another on more than one occasion, which in of itself is extremely broad, because that includes things like, I've sent you an angry email twice.
Yes, it is. It does. I'll go to the direct provision here. It says harassment. A person A harasses another person B if A engaged in unwanted conduct related to a relevant person protected characteristic, and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. But the issue is that what is an offensive environment and what are offensive comments are completely subjective, and there is no real standard in any of this about what an offensive environment means.
I've even heard and discussed with employment lawyers that this particular act can include things like looks. So this is where Sadiq Khan saying staring at a woman on a train is sexual harassment comes from. It comes from this legislation.
Yes. Really?
Yes.
Is that directly where it comes from?
Yes.
So
what's also an issue with this legislation is that it it isn't just civil legislation. This doesn't just apply to employment tribunals.
No.
It also applies and is starting to apply to criminal law as well.
Yes.
Because, as far as I'm aware, nobody has been prosecuted for harassment under Section 26 of the Equality Act or 27. However, about 6 months or so ago, there was a story on Lotus Eaters, and they were publishing an advert from some police department saying that harassment only need happen once for it to be a crime. And this is where that comes from.
Okay. I did know that this potentially could apply criminally. I know they haven't been heavy-handed enough to do it quite yet, but some of the decisions we'll get to have applied it criminally. I can't remember. Is the Richmond Pharmacology versus Diwali one? Is that a criminal case?
No, it's a civil case.
It's a civil case. Okay, I know single instances have been applied in civil cases, which we will get to, but the single act of harassment, the single comment that could lead to a prosecution, is possible under the Equality Act. You could be prosecuted for harassment, which is a very serious crime. Criminal harassment is.
Yes.
It carries quite the penalty. It is something that does generally require a custodial sentence if it's aggravated, especially if it's racially aggravated harassment, which, or if it's aggravated by, say, any of the protected relevant characteristics of the Equality Act. Because I've put here in the notes, and it is something I've banged on about as well, but the difference between the Race Relations Act and the Equality Act, even though the Equality Act incorporates most of the things in the Race Relations Act, is the Equality Act adds all of these different qualifiers. It adds in disability, it adds age, it adds gender, it adds race, it adds religion or belief, it adds sex, it adds sexual orientation, and it does this for all the other acts as well. So everything in the Equal Pay Act, the Sex Discrimination Act, and the Disability Discrimination Act that would apply to those specific groups also applies to racial groups. So it's not only an amalgamation of all these acts, it broadens out all of the instances of possible discrimination to anything that would apply to any other group, to the point that you end up with nonsensical stuff, where you could have someone who's discriminated against in terms of their religion when it comes to their sexual orientation. It's a bit of a funny one, but all of this long list of characteristics is all over the Equality Act, and all of the previous provisions that were simply meant for the Race Relations Act now apply to any protected characteristic, which really is how you got all of the trans stuff, and why you can push basically anything into the mainstream via the Equality Act. Because as I pointed out, as Evelyn's pointed out, as a lot of people point out, a lot of the trans stuff doesn't make any sense, and it has come from quite a centralized place. But the way they're able to do this is because the Equality Act has turbocharged all the previous provisions that was really meant to stop the National Front. Let's be clear, the Race Relations Act was very squarely directed at political activism from people like the National Front. It essentially criminalized them. But now, if you have activism against any of the new frontiers of these characteristics, you also feel the full, iron fist of the law, as if you were, say, like a 70s neo-Nazi, which is, it's something a lot of people haven't quite come to terms with the Equality Act, because it does make it very scary, and a lot of people, when they figure that out, tend to do the if you're an employee, you do the equivalent of kind of hiding behind the couch. But it is something to keep in mind that all the provisions of the Race Relations Act, as heavy-handed as that was at the time, now apply to all of these protected characteristics. And it's like it is the ever-expanding civil rights era. It's the civil rights era, but for everything that the regime wants.
Yes. And what's interesting here is, especially in the UK context, in America, there was and still is a very well-organized movement against civil rights legislation, whereas I haven't heard anybody who isn't outside of our circles, maybe the MRA types, mention affirmative action or positive action and discuss those policies.
No, really, because Britain never had like a civil rights era. There was never Jim Crow in Britain. There was never codified segregation in Britain. Everybody who is a British citizen or British subject, which was the distinction, both of those categories had the same standing. And really, law didn't make mention of race, it made mention of nationality and also, subjects of the crown, which is how our law was written for hundreds and, well, thousands of years, really. So it's a nonsense with previous legal cases in that a lot of this stuff is kind of standing on its own. It is something that has been created whole cloth since the late 20th century. And as many people have said in chat, and a good point is that the Equality Act is the closest thing I think we have to a constitution, or at least in terms of people's rights in Britain. It is the closest thing we have to like a Bill of Rights.
Yeah, certainly. Because the Equality Act is specific where the Human Rights Act is vague.
Yes.
So in terms of the Human Rights Act, it lays out that people have all the rights that you would expect, but they're qualified rights. And what the Equality Act actually does is it lays out how those qualified rights should be applied.
Well, the Equality Act, and I've read it here in the notes as well, it seems to me as a law that is both ultra-specific, but also not specific at all. It manages this weird tightrope act where if you were interpreting this as a judge, naively, if you were trying to do the best you could and you had no prior knowledge of British law, I don't think you'd be able to enforce the Equality Act. Because as we talked about with the harassment provision, certain bits do not have enough clarity for you to reach judgment.
No, they don't. But what's interesting there is, and vague legislation has its purpose, and vague legislation is quite common in other areas of British law. So domestic abuse legislation is very vague.
Yes.
What happens...
I said the MRAs have mentioned that to me before when I've spoken to them.
Yes. So the point of vague legislation is that it applies so broadly that it can include anything. And it will be enforced, obviously, in a way that is really unfair. So my favourite example of this is non-molestation orders. Molestation isn't defined in the Act, and the reason for this in legal textbooks is they don't want to give the respondent any loopholes.
Ah, fair enough.
So the point of vague legislation is it applies to anything.
The point of this is that you have to trust and be trusted by, in many cases, the people who apply this legislation. It is a matter of trust, of mutual trust, really, and that is not something that exists in modern Britain at all, and really something that our legal system at the moment seems to be structured around not existing, especially a lot of the legislation that we see now coming through, and a lot of the practices we see now is very indicative of an extreme low trust society. Yet a lot of our laws are geared towards a higher trust society where we can put our faith in our upper classes, our elites, to interpret the law fairly, because it used to be thought in the past, well, why wouldn't they? That'd be bad for them. That'd be bad for them. But that old gentleman's agreement of old England has long since broken down. The last point I went to cover was the quick kind of Richmond pharmacology versus Diwali case, because I've never heard of this before, and this is extraordinary. Because this was judged as violating the Race Relations Act. This is pre-Equality Act. This is 2008.
Yes.
Do you want to give a quick outline of the case? Because you brought this to my attention.
So there are these two employees. One's a lady from an Indian background, and the other is her male colleague. The Indian lady, I believe, was getting married, and the male colleague made comments to the effect of something culturally insensitive about India. I believe it was a statement about curry.
Oh no!
Having lots of people there.
It actually wasn't. I looked into this. Your slide is correct. It is an offhand statement about being married off.
That's it.
He simply used the phrase "being married off." I'll give you there's actually a quite good rundown here. The This is Richmond Pharmacology versus Diwali. Oh wait, I'm not pronouncing that right, but I don't fucking care. The Employment Appeal Tribunal has held that a remark by a director to a female manager that she might be married off in India constituted harassment within the meaning of 3A of the Race Relations Act 1976. Harassment is defined as being where, on grounds of race or ethnic national origin, a person engaged in unwanted conduct that has the purpose of affecting or violating another person's dignity or creating intimidating, hostile, degrading, humiliating, or offensive environment for that person. So exactly what we talked about before. And this was judged to meet the criteria. Mr. Val, who is of Indian origin, was a project manager at Richmond Pharmacology. She handed in her notice, giving 1 month's notice rather than 2, which was informally agreed. Given her senior position, this caused practical difficulties for the medical director, Dr. Loch, who also perceived that the quality of her work had begun to fall off. A meeting about her performance was held between Mr. Valley and Mr. Loch, at which he is alleged to have said, "We will probably bump into each other in the future, unless, of course, you are married off in India," which is a completely, that is so innocent, especially in that 2008, as to be unremarkable. An employment tribunal commenting that this had been a single ill-judged comment rather than one intended to cause offence, found that Mr. Val had been harassed and awarded her £1,000 for injury to feelings, which is a little bit of a token amount, but still it's embarrassing for the company because they have had a racial harassment settlement going favourably against them. And that is the real headline thing here, the fact that they've had a racial harassment suit go bad, and that's very bad PR for them. But there's just the line there, "We'll meet again unless, of course, you're married off in India," which is, one, it's what they do. Indian people talk endlessly, especially Indian men, of going back to India and finding an Indian wife. Pakistani men too do this. And Indian women talk about going back to Pakistan and India and finding an Indian or Pakistani husband. It's a very common cultural trope and trait that they accentuate themselves. If you've ever worked with an Indian or a Pakistani, you know this. In fact, it's a cultural thing in media too. This is very unremarkable as a comment. It's perceived racism, and as perceived racism, it was judged to be within the bounds of the old Race Relations Act, which is nowhere near as onerous as the Equality Act. Yes. What are your legal thoughts on this then? How did they get away with this? First of all,
I'm going to talk about access to justice in a minute, but when you create legislation that is this vague, it's a question of access to justice. By the time we are in now, you've had so many diversity hires pumped into the legal sphere who owe their very careers to woke jargon and garbage that anybody enforcing this stuff will probably be a diversity hire and be as left-wing as humanly possible. But the way they get away with this, the way the government can get away with implementing legislation that is this bad, is nobody fucking reads it.
This is true, and this has been the whole kind of project of the of this channel, really, as we've noticed that even a large part of the supposedly kind of dissident voices who are more mainstream do not read the legislation. You'll not find discussions of the inner workings of British legislation, say, at GB News. You just won't. No. You also won't find it it's not really in many of kind of the more talking head culture war places either. People do not understand that culture is downstream from law, and therefore they do not value law as highly as those who set law, who do understand that. And that does seem to be the main problem, but do go on.
So in some instances, lotus eaters have actually been okay on this, and I think that's partly due to yourselves and in some cases me.
There's good. I would not disparage them as an organization. I think that they have good people.
No, I wouldn't. They're fine.
They are, but I will give a shout out to Harry. Harry's been very good. He's been very good at crediting us, and he's used quite a few bits of our stuff. And it's good that this is being paid attention to, because it is kind of, a lot of people think that most people would fall asleep. I mean, we do have 90 people watching, because ostensibly talk about the dense legal implications of the Equality Act, which I'm always impressed by people's tolerance of us going into the weeds somewhat. But yeah,
Certainly.
I think you're right. People just don't read it.
Yes, people just don't read it, and it's quite annoying because I see lots of people who are new arrivals to our spheres, whether they're bad actors or not, and the way they talk about public policy in such a vague way constantly, you're just thinking, you have no fucking idea what you're on about. And I'm not going to name any names, but the reactionary feminist lot, most of them are being pushed because they've got think tank backgrounds or whatever. But the way they talk about policy and legislation in such poor detail, it makes you think, okay, well, this content and this way of arguing and fighting a culture war is specifically manufactured, because once people start having conversations about specific bits of legislation, people can start having conversations about why it should be repealed, which is a more dangerous conversation to have, certainly for the regime, than, oh, there is this vague cultural thing going on. So you see it with migrant hotels and that type of thing. You'll have everybody from PA to GB News complaining about it, but nobody discusses the legislation that makes the Home Office do this.
No, and we're going to at some point. I'll probably have you on again for it, but I want to tackle the Modern Slavery Act, which I think is low-key one of the most important pieces of legislation currently on the UK books, because it makes the deportation of migrants impossible, especially if they get a care for Calais lawyer to have access to them. Because if you state that you were trafficked, the Home Office has guidance which says that they cannot disbelieve you even if you prove to have been lied about things before. There's actually internal guidance in the Home Office about that, and we'll be going over that on stream at some point. Because
I can believe that fully, because the Braverman's bill, the illegal migration bill that's getting passed through at the moment, I did an article on that, and the problem with that article is all the zero tolerance for illegal migrants applies unless they claim they've been trafficked, or in some cases have been trafficked, because human trafficking as a definition is so broad and has been further broadened that it can basically include anything.
Yes, it can do, but not to spoiler at that discussion. Is there anything you want to say before we end here, since we are coming up on the hour? And we've also kind of gone over a lot of the points we wanted to anyway, so...
Yes, it's been a very productive stream. Please read my articles and pay attention to legislation. If you see someone talking about policies or cultural phenomenon and they're not mentioning government policy or legislation, then they're probably someone not worth listening to. So I'll give you an example. If you see someone talking about, oh, there needs to be more male teachers, and they don't explain why, or they clearly don't understand why there were less male teachers now than there were in the 80s, then they're just not worth listening to, because at best they don't know what they're talking about, at worst they're being promoted. And if you need help with public speaking or anything like that, please message me and we can work something out.
Yes, it is always good to have you on. It's always good to get your kind of more legalistic perspective, since I am not somebody from a law background. I will quickly do a bit of my own promotion. If you guys do want to support the channel, we are still fully monetized. So super chats, super stickers, all of that stuff, and you can leave super thanks in the comments. Of course, the best way to do it, which is the pinned thing in the live chat, is the Ko-Fi link. If you wanted to support us, there is another option, which is the Anti-Politics Substack. There we go, sorry. A lot of you have chosen to do that, and I'm very, very happy about that. You guys have been very good at supporting us over there. We've basically had our subscriber base quadruple since I started highlighting it, so thank you. Very, very good. Again, thank you to our members. I see you, John Morton, Anthony Keane. I mentioned you both at the beginning, and there's been a couple of others who popped in, but that is a good recurring way. Interacting with the videos just helps people see them, but a lot of you do your algorithms, and as I mentioned earlier, it's being promoted here here on the Substack, but we do have our No More Scotland thing going on in October. So we do keep ourselves quite busy. There will be something else on the Substack this week that isn't just chilling something else. Don't worry. If you guys want to... if you guys do want to support us on the Substack, sorry, you do get all of our research notes, and you also get access to all of these streams as audio podcasts with no ads that you can play in the background, because I know YouTube makes you pay premium for that. And I only realized when my free YouTube premium that came with my old kind of phone contract ran out that was a premium feature, because I've been getting it for years and not realizing it. I was like, wait a minute, YouTube makes you pay for this? What the fuck? So yeah, you can get those. You can get those there though. Apart from that, though, I think it's been a very decent discussion. And yeah, if you, a lot of people have challenged me on the whole law being upstream from culture thing. But really, if you read the Equality Act and you look at how it's applied in reality, it's a great demonstration of how you can win a culture war with a massive, powerful piece of legislation. That you can just smash people with it. And the Equality Act...
Yeah, I would agree with that.
Yeah.
I certainly would agree with that. I think law is maybe not the top of the river, but it's certainly very high to the source.
Yes. It's very powerful making something illegal if you have a Western country like Britain where people do still, by and large, the native population, respect the law. This is a shockingly law-abiding nation with its indigenous peoples. So it gives me great heart, but it also gives me great sorrow that people aren't as prone to acts of rebellion. But it has made us a remarkably stable nation. But I will say thank you for coming on Reactionary Reading Law. It's been very nice to have you here.
Always a pleasure to come on.
Yes, I will say have a good night from me, and yes, it's time. It is time for the outro music, if I can find it, since that has become a tradition recently. But we'll see you guys on Monday, and have a good night.